Good afternoon. Welcome to our weekly webinar series on the legal issues relative to the coronavirus. Welcome to all friends and clients of Schoeneck King. We will continue to do this webinar for as long as we need to. I think most folks are also aware that we do weekly or sometimes daily pop-up webinars on other topics as pertinent. So please check your updates in your email, check our announcements for topics that may be of interest to you. I would like to start today with just a word of encouragement. I continue to be beyond impressed with the integrity, the compassion, the determination, the dedication, and the passion of everyone, all of our clients and friends, as we confront this situation. The quality of the discussion, the concern that people have, and the willingness that everyone has to, undergo what is an incredible disruption and try and do things to the best degree possible is just very impressive to me. So I would just offer everyone a word of encouragement. Keep up the good work. Hang in there. Be safe. And we're all in this together. With that, by way of introduction, we'd like to start today with Jeff Shear. Jeff is a partner in our business group with a specialty in healthcare, and Jeff has been following diligently the CARES Act and is going to say a few words about loans and financial assistance, tax relief, some of the things that are going to be available under the CARES Act as we continue to analyze it. Jeff, please take it away.
Thanks, Pete. Glad to be here and to give everybody an update on where we are. A lot's happened in the past week. I think everyone's familiar that the CARES Act was signed into law on Friday. And with that, we have a whole slew of things to talk about today, and I'll try and give everybody a pretty good overview. I will, let you know that we have a pretty detailed memo on our website now, so it's always a good place to go and look for some additional detail. So the first place I just want to talk about is, what's available for our business clients, and both for-profit and not-for-profit. And the CARES Act came out with emphasized two loan programs, one of which is currently available. The other will be available very soon. And one of the things to note is, as we go into this conversation, is that the CARES Act is federal legislation. We are still waiting for both the Small Business Administration and the U.S. Treasury to provide us with the regulatory framework that all this is going to work under. So as we talk about the two loan programs today, one of which is the Paycheck Protection Program, the other is the Economic Injury Disaster Loans. I'm going to provide as much detail as I can, but this is a forever changing environment. We hope to have additional detail really within the next week to 10 days. So there'll probably be additional updates on this as we go forward. So the program that everyone seems to be talking about, and I've been dealing a lot with, is the Paycheck Protection Program. And, first off, the intent of this program is to encourage the employers to either bring back their employees, to continue paying their employees during this really difficult time that we're all dealing with. The second program, the Economic Injury Disaster Loan, is really intended to provide long-term loans for people who have, or businesses that have been really severely impacted by the COVID virus. So first, there are a couple of things that you have to think about in terms of which loan program is right. One is, what your current level of employee number is, whether you plan on bringing back employees, cutting back on your employees, because the number of employees is pretty impactful on whether the Paycheck Protection Program is the right thing for you, or whether the EIDL program, the Economic Injury Disaster Loan Program, is right. A couple other things to think about is the current state of your lending and whether that permits additional borrowing, whether there are any loan covenants that may be blown by additional borrowing. So it's something also to think about. And also just your general cash flow needs. So let's get into it. The Paycheck Protection Program. Most businesses, all businesses with under 500 employees are going to be eligible to participate in the program. There are exceptions to the 500 employee test. There is a list of potentially, and I say potentially because we're still waiting for some direction, but some employers with over 500 employees may qualify depending on their NAICS code. And that's the code that you usually include, I think, on your tax return. It kind of designates what industry you're in. So there are some exceptions to the 500 employee rule that are to note. The amount of the loan, as probably many of you have heard, is based on your average payroll over the past 12 months. The amount of the loan is 2.5 times your average payroll over the past 12 months. So that's a number to look at. And the question is, what goes into calculating your payroll costs over that period of time? You're looking at a very broad definition of salary, wages, and other compensation. Your amounts paid for healthcare, amounts paid for retirement benefits. One limitation is if you have employees that make over $100,000, the amount of their compensation in excess of $100,000 is not included in that calculation. You include your income withholding taxes, and that's generally how you come up with your payroll costs during that 12-month period. Take the average, multiply it by 2.5, and that's your maximum loan amount. That doesn't mean that that's the amount that you have to take, but that is the maximum amount that you can take. And I make that distinction because when you look at the next piece of it, which is what are the uses of the dollars and what amount of those dollars can be forgiven, not everybody may want to take the maximum amount that they can borrow. So the uses of those monies are really payroll costs, rent payments, utility payments, and interest on mortgage. So what I've been advising clients, and I'll say here, is that it would probably, if you are qualified for these dollars and you are able to get one of these loans, to put the money into a separate account and make sure that they are used for these intended purposes. And I think that's very important when you go to the next phase of this discussion, which is what part of the dollars can be forgiven. So the amount that can be forgiven, and I realize I'm going quickly, but we only have a limited time here, but the amount that can be forgiven are your actual costs incurred over an 8-week period starting on the date that the loan is received. And those actual costs are limited to payroll, rent, utilities, and interest on mortgage. So you really want to make sure that if you are able to get one of these loans, that you're using those loans for those purposes and not for other purposes which may affect your ability to have the loan forgiven. That amount, again, calculated over an 8-week period, so you can see where your loan amount is 2.5 times the average payroll cost over the preceding 12-month period. Your forgiveness amount is only measured over an 8-week period, but includes payroll plus a few other things that I mentioned. So that's why you have to look at the numbers and how they work out. If not all the loan is forgiven, the balance can either be repaid or it can be termed out for 10 years at 4%. If monies are not used for their intended purpose, then the forgiveness rules will not apply. There's also limitations on the forgiveness based on the employee level that you have during this 8-week period. So the forgiveness will be reduced if you do not maintain the same level of employees during that 8-week period that you had during one of 2 prior periods. The 2 prior periods that they're looking at that you can choose from is really the first 2 months of 2020 before all this started to occur. So really January 1 to February 15th, or last year, 2019, from February to June, which is kind of the same period we're looking at now. You look at your employee level at that time and compare it to the employee level during the 8-week period. So that amount, that level of employees, to the extent that you have fewer employees during the 8-week period that you have the dollars as compared to one of those 2 periods, and you pick the period you want to compare it to, that could affect the amount that you're forgiven. The other thing that could affect the amount you're forgiven is if you reduce compensation during that 8-week period. And if compensation is reduced by 25% or more for your employees that make under $100,000, that's going to reduce the amount that you can be forgiven. So that's a broad stroke on the forgiveness, on the Paycheck Protection Program. The other piece of it that I wanted to talk about briefly is the Economic Injury Disaster Loan, which is a loan that is available immediately now. You can apply for it with the SBA. It has a maximum of $2 million. There is collateral required. There may be collateral required on it, whereas on the Paycheck Protection Program, collateral is not required. And the disaster loan is not forgivable. At that loan, it can be termed out over 30 years. For-profits, it's at 3.75% interest. Not-for-profits is at 2.75% interest. So really, if you're looking at both loans, and both loans can be obtained, the paycheck has to be used for those limited purposes. The disaster loan really should be used for other purposes. If you've had increased costs for personal protective gear for some of our healthcare clients, if you had increased other costs that are outside of payroll and utility and rent, that's where the disaster loan can be used. So really, when looking at these programs, first thing to look at is, what's your plan with your employees? Do you really plan on bringing them back or maintaining your level, or is there going to be a reduction? And secondly, is what you really want to use the money for. And I think with that, that's really a broad stroke overview that I can provide right now. And I'm free to answer any questions, or feel free to look at the memo that we have online that has a lot more detail to it. Pete, back to you.
Jeff, thanks. Before I let you go, we are getting, a lot of specific questions, and I think it perhaps just illustrates the point of what you just said, that, that each individual situation is going to be different, and how these programs work and may apply are going to be different. We're getting questions about how you, calculate the number of employees and things of that nature. We really can't answer all those, but, I think the best advice is probably that people are going to need to start to work through their situation, and then, reach out, give us a call, and we can help them work through it. This is complicated.
Yeah, and I think, to that point, not to use up more time, but to that point, we have a lot of clients that are thinking about additional layoffs because of financial constraints, but layoffs now are really taken into account, or could be taken into account, when looking at the employee levels and the forgiveness amount if people aren't rehired within a certain time period. So there's a lot of technical details that I think really need to be hashed out on a case-by-case basis.
Okay, thanks, Jeff. We're going to turn now to Sanjeev D'Souza. Sanjeev is a partner in our Albany office, practicing labor and employment law, and he's got the difficult task of giving us highlights on the Families First and CARES Act from an employment perspective in a relatively brief period of time. So Sanjeev, take it away.
Thanks, Pete, and good afternoon, everyone. So I'm going to try to provide somewhat of a high-level overview of the Families First legislation, and that's broken out into two parts. One is the Emergency Paid Sick Leave Act, and the other is the Emergency Family and Medical Leave Expansion Act. So the first one we'll refer to typically as EPSL. The other one is the EFMLA. Now, both of those statutes are slated to take effect tomorrow. So there's going to be a lot going on starting tomorrow, and probably quite a few questions about how these provisions work. I will note that the U.S. Department of Labor has issued guidance documents. They're posted on the website. Over the weekend, they provided a significant number of supplements to that guidance that's helpful and it's worth looking at, particularly for some of the exceptions that apply, questions like intermittent leave, et cetera. I'm going to touch on those things briefly, but it's worth looking at the guidance, and if there are more specific questions that you have about how to handle a particular situation, we do encourage you to reach out to us, and we're happy to try to help you walk through it. So as I mentioned, it takes effect tomorrow. The sunset date is slated as December 31st of this year. One thing to keep in mind, though, if you do have employees who have been out on leave that might be covered under any of the provisions of either statute, there is no retroactive application. So, for example, if somebody was home with their child because of a school closure prior to tomorrow, you don't count that time or any pay that they received against any pay benefits they're entitled to under either statute. So both of these statutes apply to private sector employers and public sector employers. For private sector, it's employers that have 500 or more employees. And so one of the questions that comes up is, well, how do you count that? And the short answer to it is you count it at the time the leave begins. And in counting, you're counting all of your employees, your full-timers, your part-timers. If you have employees working in other states, you count those as well, including the District of Columbia and territories and possessions of the US. You also include employees who are on leave in that count and employees that you might jointly employ with another employer. So for example, if you are using temporary employees and you're considered a joint employer under your agreement with the temp agency, you would include those employees in your head count. There's another provision for counting day laborers that are provided through a temp agency if you have a continuing relationship with those individuals. So that's for purposes of counting for the 500 employee cutoff. For public sector, for both statutes, most non-federal public sector employers are covered. EPSL will cover most public sector employers. The EFMLA is a little bit more limited for the federal, but I'm not going to get into that right now. There are exceptions that are important here, even for covered employers, and one of them, it allows an employer to exclude from the coverage and the benefits provided by these acts healthcare provider employees and emergency responder employees. And one of the questions that came up, because it wasn't defined in the legislation, who is a healthcare provider employee and who is a emergency responder, that was addressed in the guidance issued by the department over the weekend. I'll touch on that in just a moment. You do have a notice posting requirement if you're a covered employer. There is a notice that the department has generated and made available on their website. So I encourage you to find that and post it in accordance with the requirements. If you have employees who are teleworking, you can provide it to them and meet the posting requirement through email. You can also post it on websites and intranet sites. Let's jump over to the question of pay. So one of the questions, before I get to that, one question came in as to whether this covered 500 or more employees. The answer is these statutes cover employers who have less than 500 employees. If you have 500 or more, you are not covered by these and subject to these statutes. In terms of pay, let's talk about that and what employees might be able to get under these statutes. For the EPSL, which has 6 different types of reasons why an employee might be eligible for this emergency paid sick leave. One is because they're under a mandatory quarantine order. Another is because they are sick but have been recommended to quarantine by their healthcare provider. A third is because they are experiencing symptoms of the disease or the virus and are seeking medical treatment. A fourth is because they are caring for somebody who meets any of the first 3. A fifth is because they need to be home with their child because school or daycare is closed. And the sixth is sort of a catch-all about other reasons that the similar conditions that are designated by federal officials that an employee might be able to take leave on. We don't have any real guidance on that at this point. I'm not going to really cover that. But for EPSL purposes, if an employee takes time off for the first 3 because of their illness or quarantine orders or recommendations, they get their regular rate of pay up to a cap of 511 with a total aggregate amount of 5,110. If they're taking leave for the other 3 reasons, they get 2/3 their regular rate, cap of 200 a day, and 2,000 total. For the expanded FMLA, that's leave that the employee is taking because they need to be home with their child, and they can take up to 12 weeks of time because they need to be home with the child, and that's because the school or the daycare provider is closed. The first 2 weeks are considered unpaid time, but they could use their emergency paid sick leave to cover those first 10 days. but the remaining 10 weeks are paid, and they're paid at 2/3 the employee's regular rate of pay, again, up to a cap of 200 per day and 2,000 total. For the EPSL, it's up to 80 hours of sick leave. For full-time employees, and for part-timers, it's based on their average regular schedule over a 2-week period. If they don't have a predictable schedule, then the guidance says look at the prior 6 months and average their weekly hours worked to determine how many hours of pay they have available to them. Okay, let me run through a few additional things because I'm running out of time here. An employee can ask to supplement their paid leave under either of these statutes, but they can only do so if the employer agrees to allow them to supplement it with accrued time that they already have. A question will come up, and I'm sure people have questions about this, if you have employees that have already been furloughed or laid off, or if they are laid off after the effective date, are they still eligible for either of these benefits? The short answer to that is no, they are not. If they were receiving the benefits, but then laid off at a subsequent point, they're entitled to the benefits from the effective date when they started receiving it until the date of layoff. For those employers that have employees that either may meet the definition of a healthcare provider or a first responder, I would encourage you to take a look at the guidance document, which is Q&A 56 and 57 in the DOL's guidance that they published over the weekend. That is pretty broad definitions for both, and can cover many of the employees of healthcare provider employers. Very briefly, I want to touch on intermittent leave and the availability of intermittent leave on both of these. For an employee that's teleworking, if they need intermittent leave to care for their child who's home from school or for some other reason, they can take it intermittently, but only if you as the employer agrees to allow it. A separate standard applies if the employee is still working on site. If they're working on site, they can use intermittent leave again if you, the employer, permits it, but that's limited to if the employee needs to be home to care for their child because of the school closure. It does not apply to the other forms of leave under the EPSL because they're ill or subject to a quarantine order for some fairly obvious reasons. Health insurance, if the employee's on health insurance, that should still continue while they're on these leaves. They are required to pay their normal their share of the premium contributions. So with that, I'm going to stop talking. I'm sure there are many other questions. We're happy to help try to answer these. We can do so via email as well as through calls. So we're available if you need us. And thank you for the time. I apologize for running a little long.
Sanjeev, thanks. Again, we're getting a lot of questions that are very specific that we, just don't have the time to answer. And I'm struck by the fact that we have 3 major pieces of legislation, if you include the New York State paid sick leave provisions and the 2 federal pieces of legislation that have been passed in the last week and a half. And ordinarily, you'd get a ton of lead time and really an opportunity to think through those issues and figure out how they would apply to you and how best to apply them. We'd probably have a series of webinars and discussions and the ability to do white papers. And all this is happening under a very compressed time frame. So my solution to this has been on the employment side for people to sit down and basically do a checklist and run through the individual factors with respect to each employee or group of employees, figure out which statutes would apply, what rights they afford, and determine from there, how you're going to be able to respond. So I also did want to say a quick word before I move to Katie on updates from Albany on the unemployment insurance provisions in the CARES Act. I know that a lot of people are trying to digest those, and I will just give you a brief summary of the highlights. First of all, and it's been widely reported, and I think people know at this point, But the backbone of the statute is an increase of $600 on top of whatever benefits individuals are entitled to under state law. In New York, that means the maximum benefit in New York is $504. That means that somebody who gets the $504 for a limited period of time would get an additional $600, taking them to $1,104. And it is true that for some people that might be more than 100% of their wages. That's in the statute. I believe that was intentional in the sense that it is relief and in the sense that it's easier to calculate than doing individualized calculations. Second major feature of the unemployment provisions of the CARES Act is that it increases eligibility for individuals who would not otherwise be eligible: independent contractors, sole proprietors, people who've exhausted their unemployment benefits, and that piece is also retroactive to January 27th. And so a broadening of the people who might be eligible for unemployment under a second provision of the CARES Act. There's a third provision that extends eligibility for unemployment benefits for up to 13 additional weeks. Again, using the New York example, add 13 additional weeks to the 26 weeks that was previously available, and you end up with up to 39 weeks of eligibility. There's another provision in the Act that waives the waiting period. New York had already done that, so benefits can kick in almost immediately. There are many unanswered questions as to how these will be interpreted and what the impact of this will be. And it's also in tension with some of the things that Jeff talked about. We are talking about programs that are designed to keep people on the payroll and provide incentives and relief if you do that. And then you've got the unemployment insurance provisions that will address when people are not on the payroll. So very broad unemployment insurance relief, very sweeping, and something that we'll have to keep our eye on. So with that, I want to turn to Katie. Katie Anderson is in our Albany office. She has been following the developments, the daily developments, and I want to ask her for an update on what we're hearing out of Albany. Katie, take it away.
All right. Well, it's actually now it's nightly updates too. So this week we are looking at, every week we've heard, we're looking at, this is unprecedented. Everything is unprecedented. This week is ultimately so unprecedented in New York's history. I cannot stress that enough. Not only do we see the number of cases in New York and all over the country continuing to climb. New York now has, the governor announced today, over 75,000 confirmed cases. You also have the state budget is due tomorrow. And a lot of people have been asking, why can't they just delay the state budget? Why can't it, why is April 1 the deadline? It's in the New York State Constitution. So they can't simply just, they can't just wave it away. Certain state workers won't be paid if the budget doesn't go through. So that is happening, and they will be legislature will be remotely voting on this budget. It is, again, unprecedented how little, access or knowledge that there is about what's actually going to be in the budget. So that will be big thing happening this week. So in addition, there's been there are no updates on Matilda's Law. That is not out in print. And so that's just an update from last week as well. If we could go to the next slide. We have seen a lot of the executive orders, but there are less executive orders that have been issued this week than last week. Most notably, you have the 202.13, and that one, it extends the New York pause until April 15th, and it changes certain standards. There are two links I've provided here. I'm just going to leave it up for a little bit. I'm not going to go into detail about these two things because we're running short on time. So please, employers, please go check that out. Both of these links are very important. They are reflected to update the CDC guidelines on when people may come out of self-isolation and when essential personnel may return to work either after having COVID-19 or being exposed to COVID-19. Please read that. Any questions, please get in touch with me and we'll be happy to help. But I know that our time is running short, so I'm ready to pass the ball on.
Katie, thanks. Appreciate all the updates. We're going to turn to Steve now. Steve, Steve Ricca is a partner in our Buffalo office, and Steve is going to talk to us a little bit about the OSHA issues, the latest guidance, and some of the things to keep in mind there. Turning it over to Steve. Thanks.
Thanks, Peter. I'm also going to have to provide a very sort of high-level overview of recent OSHA guidance on COVID-19 issues. I posted a detailed article on the bond website. You can find that under News and Insights. When you get to that page, there's a yellow box called Articles. If you click on that, you'll be able to view in more detail what I'll be covering today, along with links to everything that I'm referring to. Obviously, this pandemic is putting workers of all sorts under exposure risks, and the risks are similar to the ones experienced by the general public. Clearly, there are certain industries where the risk levels are higher, healthcare being at the top of the list, dentists, labs, airline operators, border protection, solid waste, the list goes on and on. What OSHA is doing is issuing guidance to help businesses, help all employers have an infectious disease preparedness and response plan in place. It is a recommendation that OSHA is making for everyone, and it makes good sense to do so. The detail and length of these plans will vary depending on your workplace circumstances. We all know that under the OSHA General Duty Clause, employers have an obligation to have a workplace free of recognized hazards. The extent to which COVID exposure will be in the fold is an evolving issue. It evolves in response to CDC guidance. It evolves in response to things like the executive orders that Katie was discussing. But if there's one takeaway today, it's familiarize yourself with how to put together an infectious disease preparedness and response plan, and put one in place when you can get to it. We can go to the next slide. So one of the links in my article is to a March 2020 OSHA publication 3990. It's called Guidance on Preparing Workplaces for COVID-19. For most employers, as I said, the protections will involve an emphasis on basic infection prevention, the sorts of things we're doing right now anyway. In addition to tracking agency guidelines and the like, employers are going to need to look at their own shop and make some observations about what sorts of levels of protection make sense. This triangle that's on the screen is a visual depiction of the concept that most businesses will fall into the lower risk category, that blue band at the bottom of the triangle. And within that particular context, you're going to be looking at basic infection prevention measures and things that are sort of consumer type responses. As you move up the risk pyramid that OSHA has dubbed this, you get into what I would call the hero category at the top, the folks who are on the front lines, working in hospitals, working sadly in morgues, and being in close contact with folks who are known or suspected to have been infected with COVID. In that smaller context, you're going to have a much higher level of protection required and a greater combination of protections. We can go to the next slide. Now, this slide here is my attempt to sort of encapsulate what risk categories OSHA has identified in its guidance. The guidance document is intended to be general. It's intended to encourage some level of improvisation. With that spirit in mind, I've sort of tried to grab some of the key examples of what sorts of work exposure would put you in a particular risk category. Lower risk is self-explanatory. You have very little contact with the public. medium risk, which the examples of which are depicted here. This could include, frequent contact with travelers, schools, high density work environments, high volume retail. And as you move to the right, you get into, again, the category of doctors and nurses. The protections that OSHA and the preventative and response measures that OSHA recommends are lumped together for high and very high risks, because apparently, there's not a material distinction between the two, with the exception that the very high risk category has much more likelihood of aerosol generating procedures, the exact kind of thing that a human being does not want to be doing during a pandemic. So hats off to healthcare providers everywhere. An aerosol generating procedure would be such things as intubation, cough induction procedures, bronchoscopes, some dental procedures, invasive specimen collection, all of these sorts of things. It's intuitive that they would require higher levels of process, higher levels of personal protective equipment, greater institutional and administrative controls. We can go to the next slide. So all employee risk levels, regardless of where you fall in the pyramid, regardless of which category you would fall in the chart, you're going to need basic infection prevention measures. Stay at home, wash your hands, flexible workspaces. We've been hearing all about this for the past couple of weeks, so I won't really dwell on it. Your plan can and probably should say something about the company's adherence to public health guidance concerning flexible sick leave policies and the like. Again, those have been the subject of separate webinars by bond attorneys, and you can find information on that on our website. Next slide. So once an employer goes through the exercise of trying to categorize its employees and determine what levels of protection are appropriate, you have sort of a menu of things that you can put in place if they're not already. Engineering controls, these are things that relate to the physical work environment and the equipment present there. At the lower risk category, OSHA, at least for purposes of general guidance, is saying that they're not recommending that lower risk level employees wear PPE. Certainly there should be an opportunity to do whatever makes sense for a particular workplace. So these things will vary from operation to operation, from business to business. So again, I won't dwell on the details here other than to give you a general sense of how this is supposed to be translated into a plan. Next slide, please. Now, of course, although there aren't any specific OSHA COVID-19 regulations that have been enacted, there are existing OSHA standards that can and should be incorporated into prevention and response plans. Personal protective equipment being one of the most obvious in subpart I. These are requirements that, particularly in the healthcare industry, are life-saving and life-preserving. When respirators are necessary, such as for healthcare workers, these folks already know that they have to have comprehensive plans in place to make sure that their respirators fit and that they're working properly. I'll mention in a minute about some interim enforcement guidance that OSHA has issued to make things a little bit easier in light of shortages. Certainly record keeping requirements need to be kept in mind, although I would caution that obviously an injury and illness report is one for which you have a workplace related injury that's confirmed, that's resulted in absence from work and the necessity of medical care beyond first aid. You have to sort of keep in mind that the breadth of that record keeping requirement could potentially capture a COVID-19 situation. There's obviously, you have to keep a clean workplace pursuant to general environmental controls. OSHA in its website guidance has pointed out that the hazard communication standard should be kept in mind. I suppose if you have a workplace where you are engaging in a very aggressive, robust procedure for sanitizing the workplace that would go beyond the consumer use, that's something that you have to make sure that your employees are familiar with hazards in using those chemicals. There are other regulations that I haven't listed. Bloodborne pathogens are peripherally related to the extent that they cover bodily fluids and how to reduce transmission of them. There are provisions about access to employee exposure and medical records that might be implicated. So again, take a look at the OSHA guidance, take a look at the links and the regs, and start to, as Peter was saying before, put together an inventory of laws that apply to your particular situation, which would lead me to the next slide. And that is with respect to the healthcare industry. On March 14th, OSHA issued temporary enforcement guidance, and this is to some extent a relaxation of the annual fit testing for N95 filtering face pieces. I mentioned before that the existing OSHA Reg 1910.134 requires respiratory protection programs that require a written program, medical evaluation, annual fit testing and training. In light of the current pandemic and the chaos and shortages that have resulted, OSHA is formalizing the fact that healthcare facilities can use other respirators and equipment that are at least as protective as the N95 face piece, and the examples are in the guidance. This guidance will remain in place as long as OSHA says it will. So this is not something that has a specific expiration date, so you'll have to kind of keep track of what the current status is. There's also, the guidance also makes clear that the fit testing methods can now include qualitative methods of testing only. Quantitative methods have the potential to destroy the equipment. So in the spirit of preserving supplies, this guidance will give the discretion to OSHA to not enforce a failure to comply with the usual requirements as long as the employer is trying to follow all of the other procedures and requirements in good faith. So that pretty much is a whirlwind tour of what OSHA's been doing and what all employers should be thinking about. And with that, I'll turn it back to Peter.
Thanks, Steve. Appreciate that. Lot to keep our eye on. We're almost out of time here, so I want to answer a quick series of questions on the unemployment provisions. People are asking about whether employees can quit or make themselves unavailable and still be eligible for unemployment benefits. And I think the way the analysis goes is this, that the general rules for unemployment eligibility continue to apply in the first instance, and that is where we get the calculation of a New York State limit of $504, perhaps less, depending upon the earnings level of the employees, plus the supplemental $600 that is included in the CARES Act. But the CARES Act does have that separate provision that does allow people who are not otherwise eligible for unemployment to be potentially eligible. And there's a long list of COVID-related reasons why someone may not be working, which are included there. And among that list is that someone is unable to work for a COVID-related reason. It's kind of a broad category. So to be seen whether somebody could voluntarily leave the workforce and assert an entitlement, but there's some broad language there. Second thing is, Katie did send via the chat function the links to her presentation. We got a lot of questions about that, so she sent that out. Hopefully you can see those, but if not, take a look in the chat function, and those links are there. And finally, I would say we're in addition to our pop-up webinars and this weekly webinar, we've got some breakfast briefings that we're continuing to do remotely on a variety of topics. Most importantly for today's webinar, the labor and employment topics. Those can be accessed on the events page of our website. And so feel free to go there and sign up for those. You'll get a lot of this information in greater detail. So with that, thank everybody for attending today. We appreciate you. We appreciate you coming to us for advice. Our clients and our friends, thank you very much. And everybody, please stay safe. Have a good day.